women to practice and work in this profession. So that's roughly my, that's how I've divided my lecture. Now I'll start with, and since I'm starting, I'm lucky to start, so I'm going to deal with all the favorite judgments of mine, and most of them are of course Supreme Court judgments. But interestingly, if there is this judgment of Aparna Bhatt versus State of Maharashtra, and it was actually a case concerning the imposition of a bail condition, where I'll read. It says, using Rakhi, tying, as a condition for bail transforms a molester into a brother by a judicial mandate. And the Supreme Court came down very heavily and said this is unacceptable. This is unacceptable and has the effect of diluting and eroding the offense of sexual harassment. And they said that this promotes gender stereotypes. And so they said judges play a very, very significant role in ridding the judicial system of these harmful stereotypes. And in fact, they have a very important responsibility to base their decision on law and facts and evidence, and not in this gender stereotyping. In fact, it is a must read. I commend everybody to read this judgment. It's authored by Justice Ravindra Bhatt. And it also says that further, court should desist from expressing any stereotype opinion in words spoken during proceedings. So what it says, or in the course of a judicial order, to the effect that women are physically weak, they need protection, women are incapable of taking decisions, men are the head of the household, should take all decisions relating to family, women should be submissive. So they said that please stay out of this, using these phrases either when you're hearing a case or in your judgment. These are all, as they say, purani dhakyanu si batein, inko chodo. You can't make this a part of your judicial dictum. So this is a must read, and I feel one of the most progressive judgments of our times. The other, of course, is a very famous case in recent times, which is for the first time in the history. This is the case of Ministry of Defence versus Babita Punya. I'm sure everybody knows about this. The Supreme Court granted permanent commissions to women in the Indian Army. Now, what is interesting is, apart from this right that they gave women in the Indian Army, the observations that they made while doing so. Because these observations will help every woman in this country. It is a progressive thought which has been immortalized in your books. So now let me just, I feel so happy even reading this. Now let me just quote a few extracts. It says, if society holds strong beliefs about gender roles, that men are socially dominant, physically powerful, breadwinners, women are weak, physically submissive, primary caretakers, confined to a domestic atmosphere, it's unlikely that there would be a change in mindsets. And the Supreme Court, through Justice Chandrachud's judgment, they said time has come for a realization that women officers in the army are not adjuncts to a male-dominated establishment whose presence must be tolerated within narrow confines. That, in our view, is not the manner in which steps taken progressively by the Union government to bring women into the mainstream of the army can be viewed. While saying so, they say, the salient decision of the Union government to extend PCs to women SSC officers in all 10 streams in which they are commissioned is a step forward in recognizing and realizing the right to women to equality of opportunity in the army. This marks a step towards realizing the fundamental constitutional commitment to equality and dignity of women. Now this holds good for everything, and not just to deal with the army. So when you may decide a list inter partes, but what they say will help everybody else. So the audience of a judgment is not just the two parties. The audience are general practitioners, are law students, and the rest So everything has a very far reach. The other most important judgment of recent times is the one in Joseph Schein, which was a challenge to the constitutional validity of Section 497, which is your adultery law. And again, whilst finding it to be violative of Article 14 and striking it down, they said something very important when it comes to women's rights. It says, the provision treats a married woman as a property of the husband. It does not consider the wife of the adulterer as an aggrieved person. So therefore, they said, far from the rationale of the provision suffers from the absence of logicality of approach, and therefore we have no hesitation in saying that it suffers from the vice of Article 14 of the Constitution being manifestly arbitrary. And what's important again is not just the striking down. What did they say while doing so? They said, far from being an equal partner in an equal relationship, she is subjugated entirely to the will of her spouse. The provision is proffered by the legislature as an effort to protect the institution of marriage, but it proceeds on a notion of marriage which is one-sided, which denies agency to the woman in a marital life. So, every judgment, now even in 3 minutes, I've told you 3 different subjects. So you have the army, you have something to deal with domestic relations, right? So like this, the Supreme Court, through his various judgments, have contributed to promoting women's rights. There's several judgments. I'll just mention a few, which is the Vinita Sharma and the Rakesh Sharma judgment, which was when the daughter is treated as a co-partner in the same manner as a son by birth with the same rights in co-partnery property and liabilities. Earlier they said that these rights will accrue to a daughter only if her father was alive at the date of the amendment. But the Supreme Court said, no, sorry, this cannot be. And so they read the provision, the amendment progressively. Then you have the other interesting case. Again, this is Anuj Garg versus Hotel Association of India. Now, this was a provision of the Punjab Excise Act, which was challenged, which inter alia prohibited employment of women in a premises where liquor is being served. So the whole drift of the law was, no, we need to protect her. You see, it's not very safe. But the court said, no, you please empower her. You provide safety, but don't prohibit her from being employed in a bar. You provide safety, but don't say for the sake of safety you shouldn't work there. So again, another progressive judgment in promoting women's rights. So they said very beautifully, women would be as vulnerable without state protection as by the loss of freedom because of the impugned act. Don't take away their freedom. The present law ends up victimizing its subject in the name of protection. So they said, empower them, make them, take a socially wise approach. The other, of course, is the famous Sabarimala case. Once again, in the India Young Lawyers Association versus State of Kerala, they commonly known as the Sabarimala case, the Supreme Court dealt with the prohibition on entry of women of age group 10 to 50 years into the Sabarimala temple for worship of Lord Ayyappa. The majority judgment held the exclusionary practice to be a violation of constitutional morality and fundamental rights of women devotees. Some of the very, very important observations were that subversion and repression of women under the garb of biological or physiological factors cannot be given a seal of legitimacy. Any rule based on discrimination or segregation of women pertaining to biological characteristics is not only unfounded, it's indefensible, it's implausible, and can never pass the muster of constitutionality. And they also dealt with the sensitive topic of menstruating women. So Supreme Court it's been a no holds bar approach when it's about protecting women's rights, and they've come up admirably, according to me. And Then there are other, you go back in history, these are more recent time judgments. You also have judgments like Seher. I don't know how familiar people are. There is this practice of, sex determination by way of ultrasound. It's prohibited in India, where you know the gender of the baby. And there was a time when there was rampant sex determination in this country, and after determining the sex, there was rampant, fetal abortions. And we had a legislation in 1994, which is known as the PNDT Act, which nobody knew about. So when we went to court, the first response of most people who were supposed to implement the law is that we didn't know there was such a law in existence. So Supreme Court stepped in and said, hey, there's this law, and then they gave very, very comprehensive directions to make this law effective, to work this law. So at every point, be it to wake legislation up, to take into subjects which are very, very sensitive and volatile, like, about Sabarimala is a very volatile and sensitive subject, but that hasn't stopped the Supreme Court from coming in and protecting women's rights and seeing that, all the constitutional obligations are met. Then, of course, you have the famous Vishaka case, which everybody knows about. But what is important is they went a step further in Vishaka. They saw that there's a lacunae in law. There was no legislation on sexual harassment then. But this and commonly we all know what do courts do? They interpret the law. They're not supposed to make law. But yet they felt that no, this is the need of the hour. They stepped in, they put in place a regulatory regime to prevent sexual harassment at workplace. And interestingly, it is only 17 years later that the government come with the law. So just see, for 17 years, the judgment of the Supreme Court provided a mechanism for a prevention of sexual harassment at workplace. Then you also have a lot of judgments of the Supreme Court protecting group rights of women. Women as a group, not just say two, just on subjects. Like for instance, you'll see there's a very famous Environment and Consumer Protection Foundation versus Union of India. This was when the court stepped in on behalf of the Vrindavan widows. They stepped in. They said no. They live without dignity and they live without any protection. We are going to step in. And the court, on the basis of, there were several committees, and they not only ensured that they get pension, there's a proper structure and functioning of shelters. They saw that the Vrindavan widows were given health, nutrition, vocational training, and even in terms of even setting up proper shelters. To that extent, the Supreme Court made, this is of course something the executive should have done ordinarily, but they stepped in, they said no. There is dignity of women is at peril. And they felt that, the ashrams where they were housed, they were not treated with dignity that they deserve at the fag end of their lives. It's with great sensitivity that they approached this subject. Then you have also the judgment in Buddhadev Karmaskar's case, where again it's a group interest. They looked at sex workers, they looked at their children. They said sex workers are treated as if they're outside of society. They don't get ration cards easily, they don't get voters ID, their children don't get admission in schools, but then court again stepped in and they said no, we will lay down some guidelines, we will issue directions. It was a very pending, I think it's even pending today if I'm not, it is, right? It is. Then you have other cases where you name it, any subject you take, you will have one progressive decision. Even if you look at, say, the Hindu Minority and Guardianship Act, incidentally, I must tell you, it was a very funny incident happened. I was arguing before the Karnataka High Court, and they said, no, please get some case law on the subject of guardianship. So then I asked my instructing counsel, please go look at Geeta Hariharan. So then I had appeared as a junior. So, ma'am, आप इतने साल से हो इस profession में, they were so shocked that I'd been here for so long. So it was of course a 96 judgment. Anyway, I had a hearty laugh. Yes, okay, I have to conclude. I'm sorry. Okay, I am just going to quickly go into my other subjects very, very quickly, which is the courts have played and continue to play a significant role even on the administrative side. Today, since 1950, we have only 11 judges in the Supreme Court. Only 11. In the subordinate judiciary, it's only 28%. In the higher judiciary, it's only 11%. In fact, there are 5 high courts which don't even have a single woman judge: Manipur, Meghalaya, Bihar, Tripura and Uttarakhand. So, in such a scenario, there is a dire need for having more representation. So, this is a way forward of women in the judiciary, because it symbolizes participatory democracy. It brings in diversity of opinion. When women are on the bench, they come with their own experience to the judicial decision-making process. The other significant, I know I'm running through this, there's another very significant contribution of the judiciary, which is the creation of Mahila courts in Delhi. Now, Mahila court started in 1987, and it was a very successful project. So today you have so many Mahila courts which do all cases. They are helming those Mahila courts, the 498A cases, 406, 506. Feel more comfortable when there's a woman judge on the bench. And most importantly, the people feel more confident in the judiciary, saying we're equally represented. The last thing that I want to say is that, women judges have played a very significant role on the administrative side, even when they were helming committees like NALSA, when they were member secretary NALSA, when they did, like Geeta Mittal, Justice Geeta Mittal, when she was in NALSA, what she did is she had people who were acid attack victims, transgender, were given posts of LTCs. So women even have acted so proactively and progressively even when they were head of these committees. So have more women. The last thing I want to say is that judiciary has also contributed to creation of infrastructure which makes it more friendly and conducive to women to practice. Well lit. You have creches now. A lot of my juniors' children were in the creche when they were appearing in court. So you have creches. You also have a good CCTV network. So I end by saying more power to women, and we should always support women, and we should always be together.
Thank you, ma'am, for such a marvelous speech. Now, I would like to call upon Mr. Subodh Patil ji on the dais to give a brief introduction of our special guest, senior advocate, Ms. Priya Hingrani ji.
Namaskar everyone. Good evening. Thank you, Archana ji. It's a pleasure to introduce Ms. Priya Hingrani madam. But sometimes it gets difficult when you introduce someone who is already well known. However, I'll make an attempt. Ma'am was born in Delhi in a lawyer's family. Both her parents, her mother and father, they were well-known lawyers. She completed her schooling from prestigious Sardar Patel School and her BA English Honours from IP College, Birmingham, and Bachelor in Law, that's LLB, from Campus Law, Faculty of Law, Campus Law Center, Delhi University. Thereafter, in 1990, she got enrolled as an advocate and she started practice before Supreme Court. And since then, she has been practicing primarily in Supreme Court and many other high courts in the country, such as High Court of Delhi, Calcutta, Bombay, Punjab, Haryana, Odisha, Jharkhand, Bihar, Uttarakhand, Jammu and Kashmir. I don't know, I may miss something, some high courts, so excuse me for that. She has diverse practice in the field of taxation, customs and excise, insurance, family and matrimonial laws, commercial laws, labor and service laws, human rights laws, constitutional law. She has been actively involved in various important cases. Recently, to cite a few, she has been involved in triple talaq case, Jagannath temple case and uniform marriage case. She is not only a lawyer, but she is also an activist, a human rights activist, especially working in the field of women empowerment as well as animal rights. She is a sport enthusiast and an avid music lover. It would be a really delight to hear ma'am's thought on today's topic. So now I request Ms. Priya Hingorani ma'am to share her views on today's topic. Thank you.
Thank you very much for such a introduction. I'm feeling a bit embarrassed and very old also. Very good evening, Geeta Di, as we call her, Geeta Di, and Anita, Bhaskar, Amit, Alpana, all my friends and senior colleagues in the audience, Madhu Sharanji, who we always look up to, and we've had a lot of good times with her. Rekha Pandey who has been part of the Hingorani chamber and been part of so many cases which my parents did when in the initial years when PIL was started. And many others. I'm sorry I can't mention everyone, but it's very nice to see all of you after so long, 2.5 years, physically together in this auditorium where we've had many good events. Thank you very much for inviting me. Anita has taken us through some of the important judgments which were very favorite to her. I had of course made a huge list of judgments across the country, but I'm not going to read out any of these judgments because I know all of you at some point or the other have gone through all these judgments and during the course of your day-to-day practice, do look into them. I'm just going to share a few of my experiences because I know time is short and we all want to hear Geeta Di as well. As was mentioned, I come from a family of lawyers. My mother was born in Kenya and shifted to the Supreme Court to practice here in '66. My father was born in Karachi and moved to Delhi in just after partition when the Privy Council was there. We still didn't have the Supreme Court and started his practice here. My parents romanced and got married in the corridors of Supreme Court. One of them was the junior of Mr. Setalwal and the other person worked very closely. My father worked with Mr. Daftari and Mr. Nirende. So we grew up in the corridors of Supreme Court hearing about their romances, about their the initial years of their practice. And when my mother, Mrs. Kapila Hingorani, came to Supreme Court in '66, there were only 4 women practicing in the Supreme Court. And within a span of 6 months, for a brief period of 6 months, she was the only lady lawyer practicing in Supreme Court. Because 3 of the others, one of them got married, the other one moved to Kerala, and I don't know what happened to the third one, but this is what the position was. They started public interest litigation in 1917. On behalf of some of the victims, the court for the first time decided to ensure speedy prosecution of those accused in such crimes, because most of them at that point in time either enjoyed the political or police patronage. And there was prolonged investigation in these cases. So the court reviewed the stage at which investigation had progressed in such specific cases and directed the setting up of special police cells to deal exclusively with crimes against women. That's when, at the first time, that was the stage when these, as we all know, the crime against women cells, the CAW cells, they came into being. Way back in '81, it was envisaged, and since then, the crime against women cell came into being, where these kind of cases were given priority and they were, investigation was done. Then in 1983, there was another case which also hit the limelight or hit the headlines at that time, was the case of Gaurva versus State of Karnataka. That was in '83, where the prohibition of practice of Devdasis in Karnataka, which was a very religious practice for dedication of girls to the temple, but then it degenerated into prostitution. So that was the case which was taken up in 83 and where the Supreme Court passed various orders. In Radhini versus Union of India, which was again in 87, the issue of sexual exploitation of tribal girls in public sector units was brought before the court, and the court passed a plethora of directions. When I joined the bar, the first case in the early 90s came to me through an NGO, that is the national, one of the NGOs of Delhi, which, because in those days, there was a procedure of fax and telegrams. And there was a telegram which came to the NGO saying that my daughter has been missing for the last 6 months. We don't know how to trace her and what to do. So we moved to the Supreme Court in a habeas corpus petition. Of course, very poor family background. And we found that she had been sold to a quota in Kasganj and for prostitution because she gave birth to a girl child. And the girl child was, of course, killed the same night, and then this girl was sold off. And why I mention this case is for two reasons. One is because I evolved as a lawyer. For me, taking up such a case, of course, I had the support from my family, but to take up such a case in court, to know how to take it forward. And why I say this is very important, we have so many young lawyers today who are coming to courts, and particularly women lawyers. I think it's very important that we mentor them and we tell them how to go about it. And the other reason is because the response of the court. The court immediately, gave directions to the police to produce the girl within 24 hours. Of course, we were looking for her in Haryana, but she was not in Haryana because there were two states involved, and we ultimately found her in Kasgan in UP. And she was produced in court in a total vegetative state. She could not walk into the court. She was carried by two lady police officers in court, and they asked the mother to identify her. The mother identified her. Of course, she broke down, cried, and she said, "Yes, this is my daughter, but this is not what the state I sent her to in the marriage." And in that case, through that case, the court not only got her medical aid, got her admitted in hospital. Of course, there were a plethora of directions in that case, but in that matter, I can say I evolved as a lawyer to know what are the sensitivities and what are the rights of and the power of the court. Similarly, in another matter, again which came through an NGO, because I had the opportunity of working with NGOs, 3 girls were kidnapped, sexually exploited, because all these 3 girls in Haryana owned land in their names, and their father had given land in their names, and the cousins wanted those land, and the girls were refusing to sign their land to them, so they got them kidnapped, sexually exploited. The Supreme Court again intervened, we rescued them. The Supreme Court itself took it upon themselves to get the land sold, accounts opened for these girls, amount deposited in their land sold, money given to them, and of course the people were punished, and those people at that time was punished. A direction to punish them. These kind of experiences that we personally as lawyers have in court, whether it's a lady colleague or a gents colleague, it helps in evolving a system. And I must say, while we are talking about Supreme Court judges and judgments from the Supreme Court, we have had amazing judgments from the district courts and the high courts. High courts across the country are equally protective of women's rights as the Supreme Court is or the district court is. I have still go to the district courts, and I can tell you with great pleasure the satisfaction of doing a matter in the district court and getting an order, and particularly orders from women judges, or whether it is really heartening. Anita said it's a comfort level appearing before women judges. Sometimes I would disagree, sometimes it's not that good a pleasure. Yes, we have some very good women judges, but at the same time, I think male colleagues are a little more sensitive to the rights of women. And we do get very good order from the male colleagues as well, male judges as well. So it is a balance I think I have found in courts across the country. Some of the other cases which of course are part of from Supreme Court, various high courts, whether it was related to equal wages, whether it is related to pregnancy, time off from pregnancy, these are all cases which were by the Supreme Court. I am not going to go into them. But yes, I do want to point out, apart from the fact that the judiciary plays an important role in looking after the rights of women, there are also issues where, whether it is, as was mentioned, appointment of judges or the attitude of the courts towards women colleagues, women lawyers appearing before the courts. That is something I think we also should discuss, because we have had occasions in the High Court and in the Supreme Court where comments have been made to women colleagues at the bar, and it is only because the bar has been strong at that relevant point and taken up the issue with that relevant judge that we have been able to support our colleagues at the bar. It's not easy. It's not easy for women lawyers in any court. But I must say, the strength of the women lawyers amongst themselves is a huge, huge back to all the women who are practicing. And that's why it's important, not only women mentoring women, it's also men colleagues mentoring women lawyers in the profession, which is equally important. We are, of course, the topic is on the role of the judiciary in promoting women's rights. But I think it's the lawyers who also need a round of applause for working and ensuring that women's rights are protected. It's only lawyers who actually take these cases to the courts, who actually argue, who actually assist the courts. So I think it's a huge applause for the lawyers who actually take such cases to the courts, which assists the court in helps them in deciding these courts. Of course, the judgment comes from the court, but we play a very important role in it. Having said that, I know time is short, and I would of course have loved to discuss some of the judgments which I think are very important. But I'll let Geeta mention some of the judgments. I'm sure she's got the same list of judgments and many more in her thing. But thank you very much. I know it's evening at 5:30 and everybody would like to go home or go back to their work. But thank you for such a patient hearing, and thank you for being here. Thank you very much.
Thank you, ma'am, for those amazing sharing practical experiences. Now, I would like to call upon Ms. Kavita ji to give a brief introduction of our keynote speaker, Senior Advocate Ms. Geeta Luthra ji.
Namaskar ji. Good evening, my friends and colleagues. Today, we are here to discuss about the role of judiciary in promoting women's rights. In this 21st century, one of the most important concerns is the right of women and their empowerment. In this backdrop, this topic is very important. It is my great pleasure to introduce our speaker, Ms. Geeta Luthra ma'am, Senior Advocate. She was awarded the prestigious INLAX Foundation Scholarship for Law at Cambridge and was obtained LLM and MPhil in International Law. She had a distinguished career in the legal field. In her long legal career, spanning over 4.5 decades, she has been active with Delhi Legal Services Authority and done several matters pro bono to help underprivileged and disadvantaged groups. Ms. Luthra ma'am argued landmark judgments in various fields and has successfully defended the rights of several members of society, including women, children, and transgenders. She had argued several prestigious matters in human rights, criminal law, and matrimonial laws. She is currently an Additional Advocate General for the State of Haryana and a Senior Counsel for Union of India before the Honorable Supreme Court. She is an accomplished lawyer and a shining example of success in women litigators. Our speaker, Ms. Geeta Luthra ma'am, has great depth and knowledge in this topic. We are delighted to have Ms. Geeta ma'am, Senior Advocate, as a speaker today regarding the topic, role of judiciary in promoting women's rights. Ma'am, at this time I would like to invite Geeta ma'am to share her views and experience.
Dear Anita, Priya, Ankit, Alpna, Bhaskar, Archana, and all other friends present here today, thank you for listening to us. I was going to have a suggestion for Archana, which was that the tea should always be after we speak so that there's something to look forward to than before we speak. But having said that, thank you all for staying even beyond the tea. Some of the judgments, we looked at several judgments, and Anita has taken you through many judgments. Some of the judgments have been discussed by Anita. Now, if we discuss the judgments of the Supreme Court, several of them are around Article 14, 15, 16 of the Constitution. A number of them are around women's rights and right to equality. Right which which Parliament has tried to also give. First, the Constitution has given us, then we have 42 or more enactments which are women-centric. I think let's look at this aspect of the law. To what extent should right to equality give special rights to women? Are we entitled to special rights? Why do we get special rights? So clearly, women get these special judgments or get judgments in favor of women because they are not empowered to the extent that men are empowered. That's why, and I quote again from Ruth Ginsburg, who was quoted by Anita. She says, a real change happens one step at a time. So while change is now happening in India very rapidly, the fact is all of us have sweated and toiled for this real change to happen a little more rapidly than it was happening earlier. And the judiciary has played an immense role in that. The judiciary has come up for every judgment, whether we talk in terms, and I was just trying to think of the various judgments, forget the cases that I may have been party to as counsel in some matters or other cases. I remember sometime in 1986, we had perhaps, or it was in the beginning 80s, we had challenged the Guardianship Act. We said it's gender insensitive, it's making the father the guardian. And I remember the judge who was hearing us at that time, he said, "Madam, wait for Parliament, we are not doing anything." Along comes Geeta Hariharan, and from Neena Deshmukh, which was the case then in hand, in Geeta Hariharan, the court doesn't really say that women are equally guardians, because the Guardian and Wards Act doesn't envisage that. But the way it said was, well, if a father is being indifferent, if a father is being uncaring, if a mother is really looking after the guardian, after the child, then she is the de facto guardian. So you really got around that provision. Sometimes the courts cannot come and change the law completely. And that you are seeing in marital rape. This whole debate that's happening, can the courts make an enactment, or would the courts be able to strike down? I'm not speaking much about it because it's a matter which is reserved. But again, the issue is the courts have tried to step in even where Parliament may have left certain lacunas. So the entire process has been extremely progressive. So when I spoke about marital rape, and in this context, the manner in which the courts, whether it's the various high courts, whether it's the Supreme Court, recently Karnataka High Court has come with a judgment on this issue. Courts have come in every enactment, in every sphere. So let's look at, we've discussed the Guardian and Wards Act. Let's look at the Criminal Procedure Code 125. There was no provision for interim maintenance. The courts brought that in terms of a judgment, because otherwise maintenance was decided 3, 4, 5 years later. So the court read in interim maintenance to be awarded in those cases. There was, apart from Section 18 and 23, under the Hindu Adoption Maintenance Act, there was no provision for right of residence till the Domestic Violence Act came in. But the courts read it in other enactments also, that maintenance includes right of residence. And that's Mangatmal, etc., judgments of the Supreme Court. Then the judgment under the Hindu Succession Act, Vinita Sharma, Justice Arun Mishra's judgment, and I can only applaud that just before going, he gave us this beautiful judgment, which really we felt was a great breather. Now you look at right of residence again. Very recently, and I was involved even in that judgment, which was called Sneha Ahuja versus Satish Ahuja, the right of what is a matrimonial home. So what was being done was that very often people would change homes in order to deprive the wife or the live-in relationship from a right of residence in the house. The courts have come in to say that you can't just oust a woman, put her into a rented accommodation, say in Saibabad, if you were living in Defense Colony, and say that now this is your matrimonial home. So Sneha Ahuja, which was a very recent judgment authored by Justice Ashok Bhushan, has laid down the law very extremely progressive, with a balance that a suit can be filed by a person who has a grievance, who has a title, to show that what she's getting. Ultimately, if a law has to survive, it has to be balanced. Remember, we have to remember, on one hand, we have a right of maintenance for parents, etc. Then we have the right for the wife. Ultimately, everything in life has to be balanced. The two enactments have to be balanced. Similarly, enactments which may be gender sensitive for women, like 498A IPC, which have been interpreted by the courts, have also given protection to men, to parents who are living separately, who are living far. Arnesh Kumar has come in. So a balance needs to be struck in life. The judiciary has to play that role. If we have to have far-reaching reforms, then the judiciary has to play that role. I wanted to say a word about Mahila courts, and about women courts. So I have one aspect to say, although I love seeing women judges on the bench, bright people, brilliant judges, and in Meghalaya and one other northeastern state, the percentage of women judges in the lower judiciary is about 67%. That means in the exams, women are definitely performing better. But when I go to a court, I should feel gender neutral. I should feel that there is no gender. I should feel whether it's a male judge or a female judge, I have the same amount of confidence. And that is why I am not one for having necessarily male courts. POCSO matters, all those matters are different because we are talking of sensitive children, etc. Otherwise, I believe that my confidence has to be in the bench, it has to be in the judiciary, it has to be in the criminal justice and the civil justice system. So that is one aspect that I want to see, and I hope that our judiciary will continue to play the role it has played. Now, this reminds me, several years ago, on behalf of Manushi, we had filed a petition in the Supreme Court where we had challenged on behalf of Ho tribal women. And that was a very difficult case because these tribal women, if they marry outside the tribe, then they are thrown out of the tribe and their property is taken by the cognates and agnates. And we were saying that this aspect of the Chota Nagpur Tenancy Act should be struck down. But the courts were chary. They said, let's wait for Parliament or the state legislature to do something. So there will always be a limit to what the courts can do. But to the extent of their limits, and now there is a challenge pending with regard to Parsis and the right of Parsi women who marry outside their faith. So as and when an infraction comes up, and Sabrimala has shown the way. Now I want to discuss for a minute Sabrimala. So in Sabrimala, the entire controversy is that women would or should be allowed to go to a temple, and menstruating women or women between 10 and 50 should be allowed also. Now the whole issue has again sprung to a lot of discussion because there are those people who are saying this is against my religious practice, and there was a dissenting judgment by Justice Indu Malhotra, and the issue was that if the ground for discrimination is 10 to 50 because they are menstruating, then that's a poor ground. There may be many grounds which may be in favor of not allowing one or the other person or gender into their argument being that there are places where only women are allowed. But the question is, what's the rationale behind it? Is it a rationale which is gender insensitive and is discriminating against women? And I think that's what we need to look at. Now, what I did want to say was that how and to what extent has the Supreme Court, insofar as safe places for women to work, how much has the Supreme Court been able to achieve with Vishaka, with the subsequent judgment of Medha Kotwal, etc. And I believe it's achieved a lot, but I still believe there is a lot to achieve. I only want, and I don't want to over exceed my time. If I'm within time, then I can speak for another 2 minutes. Is that okay? The environment for working for both men and women should be absolutely free and without any risk or tension. I should not be having to hear a male colleague telling me that whenever I'm working with a woman colleague, I'm so scared that I keep my door half open because I don't want any imputations against me. But I want a woman colleague to feel safe when she goes in and the door is closed. So we have to make sure that that's the kind of environment we provide our male and our female colleagues. So, having said all this, I want to come to one of the recent judgments of the Supreme Court, in which I was a counsel for the National Commission of Women. And that was the judgment in the POCSO interpretation under Section 7. And the question there was skin to skin touch. What is touch? What is contact? Should touch be skin to skin? Should contact be physical of two bodies touching each other? And very interestingly, and I must tell you that this debate was not just a debate which the Maharashtra High Court judge made, but it was a debate which I have seen raging both in the UK as well as in the US till it was decided in favor of the interpretation which our Supreme Court has placed on it, and which is the only logical interpretation. If somebody touches a girl on her breast or in the pocket of her trouser, and that's the case which was there in the UK, the man touches the girl from the pocket of her tracksuit and says there is no skin to skin touch. So the court came down in Attorney General of India versus Satish and National Commission of Women versus Satish that this interpretation would be against the purpose of the legislation. The manner in which the legislation was intended or was to be interpreted does not necessarily mean without a clothing. Otherwise, there would be vast number of cases where a person would be able to hide behind the law. But what is interesting is that this argument which was given there is an argument which had been put to rest in cases in the UK as well as in various superior courts and Supreme Courts, which is the district level and high court level courts in the US. So it's not a debate which was new only here, and that is an interesting debate. There is an interesting aspect that I wanted to say, that when we talk of women leaders, when we talk of percentages, when we talk that, and for that aspect I want to point out, the solicitors in 2019 in the UK, 50% were women. We have to remember this, that if solicitors were 50%, were the barristers 50%? When are the barristers going to be 50%? When are the arguing counsel? When are the litigators going to be 50% even in the UK? So these are baby steps which are being taken. I remember going to a French court in 1980, and I was overwhelmed when I saw that the 60% of the lawyers were women. When we came back to India and to practice, I saw that I was perhaps the only one or another one in the corridors of the courts. So that is fine too, but this is also fine, that we are making progress, but in future, what I want to end by saying, in future, there should be no female leaders. There will be just leaders. I hope a time will come when we will not typify a leader by saying this is a woman judge, this is a woman leader. Thank you very much.
Thank you, ma'am, for fabulous speech. Moving towards the concluding part of today's session, I would like to request Ms. Bharti Tyagiji to deliver vote of thanks.
Namaskar. I, on behalf of Adhivakta Parishad Supreme Court Unit, would like to convey my sincere thanks to our distinguished guests, Ms. Geeta Luthra ji, Priya Hindurani, and Anita Shenoy ji, for enlightening us on today's topic, role of judiciary in promoting women's rights. Indian judiciary has an important role to play in empowering the women and establishing gender fairness. The legislature can draft the laws, but judiciary can implement the laws in such a way it gives justice to all. The equal representation of both genders will influence the gender responsiveness of the courts. Now my special thanks to senior advocates and audiences as well. I would also like to extend my sincere thanks to our team, Supreme Court Unit, who have made this program successful by their tireless efforts. So kindly do like us, do like, share and subscribe on YouTube channel and follow us on Facebook and Twitter. Thanks. Now please rise for national anthem.